Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, could you imagine living under a law that has been found not once, but twice unconstitutional and having to live under that law for year after year after year? Well, you don't have to actually imagine it. You could just actually be from or live in California. We're going to talk once again about California's assault weapon ban, specifically the holdings of Miller v. Bonta and what's going on there. For those of you who geeked out on the Duncan case, the magazine ban case, we told you there would be all sorts of gamesmanship played by the Ninth Circuit. That proved to be exactly true. And we told you that they would be doing the exact same thing with Miller v. Bonta. That is, again, proving to be exactly true. There is a bunch of nefarious gamesmanship going on, and we're going to be able to connect the dots and show you how. So today, let's get you educated, and let's spend a few minutes and let's talk about shenanigans in the Ninth Circuit again. Okay, so the case we're talking about yet again today is Miller v. Bonta, the twice successful challenge to California's assault weapon ban. Now, I want to give, for those of you who live outside the People's Republic of California, I want to give you at least some understanding of the misery that these people have been through. Now, I've neglected to look up what date they actually passed this assault weapon ban. I know that California was the first state to pass assault weapon bans, but check out this timeline, because this lawsuit was originally filed back on August 15th of 2019. That's right, 4 years ago. There was a motion for a preliminary injunction that was filed on December 6th of 2019. There was an evidentiary hearing that was then conducted on October 19th of 2020. This both consolidated the injunction and the merits of the case. Now, this is all taking place down in the United States District Court in San Diego before the Honorable Roger T. Benitez. But as you can see from the date of filing to the date of actually ever having anything legitimate happen on it, we're talking about more than a year. But wait, there's more, because after the evidentiary hearing on October 19th of 2020, then there is a full-blown bench trial, which has over 14,000 pages of exhibits offered on February 3rd, 2021. So from the date of filing until the date of actually getting this case to a full-blown trial, it's already a year and a half. What happens next? The first Miller v. Bonta ruling is issued on June 4th of 2021. Now remember, the first Miller v. Bonta ruling analyzed it both under the then acceptable two-part balancing test as well as a text and history, which Judge Benitez felt was more appropriate. So this thing was really kind of appeal-proof, no matter how it went, or so we thought. But then what happened? Well, on June 10th, 2021, the state appealed. By June 24th, 2021, of course, the Ninth Circuit stays the entire enforcement of Judge Benitez's ruling, pending the outcome of Rupp v. Bonta. But then along comes the Bruin case as well. So the Bruin case stalls everything out because, remember, now there has been an appeal to the United States Supreme Court for acceptance of this case on a certiorari. But then remember what happens after Bruin is published. Because on August 1st, 2022, the United States Supreme Court GVRs the case from the Supreme Court all the way back down to the Ninth Circuit. And let's remember that at that point, the Ninth Circuit had said, hey, there's no problem with assault weapon bans. And the Supreme Court had granted review, vacated the ruling, which said everything was honky-dory, and then remanded back down to the Ninth Circuit. The Ninth Circuit then, of course, kicked it all the way back down to Judge Benitez. So then after the GVR on August 1st of 2022, the case ricochets all the way back down to the District Court in San Diego, where on October 19th of 2023, Judge Benitez then issues yet another opinion in Miller v. Bonta, what we're calling Miller v. Bonta 2, and again, applying a more correct analysis this time now, using Heller and Bruin and McDonald and all of those cases. Once again, he rules that California's assault weapon ban is unconstitutional. So this is where we jump in. We jump in right now because now, as we know, the state of California has appealed. The Ninth Circuit has accepted that appeal. And this is where I want to show you just how intellectually dishonest the Ninth Circuit is and all the nefarious gamesmanship that's going on. Because as we know, What the state of California is asking for is injunctive relief. They are asking for a stay of Judge Benitez's ruling. Now, anytime we are asking for injunctive relief or asking a higher court to hit a pause button on what the lower court has ruled, we essentially have to show two things. Now, technically, if you geek out on the brief, which we will link down below, you will see you actually have to prove four things, but we're trying to keep things real simple here at Washington Gun Law, because the two big things you have to show is, number one, you are likely to succeed on the merits of the argument, and number two, you're going to suffer irreparable harm. So what the state of California here has to show to the Ninth Circuit is, hey, by the way, we are likely to prevail on the merits of the argument. We get that this law has been ruled unconstitutional twice, but we really got it figured out this time, and we are going to suffer irreparable harm. One would think that that is an incredibly lofty burden for the state of California to reach, but au contraire, we are dealing with the Ninth Circuit. Now, in reviewing the plaintiff's arguments and objections to this stay, they made absolutely all of the right arguments. They pointed out that actually it was the plaintiffs here that were likely to prevail on the merits, because when we take a look at the clear holdings of Heller and McDonald and Catano and Bruin, we will see that there is a very clear analysis, which is this activity covered by the text of the Second Amendment? Yes, it is. It deals with the possession of firearms. And number two, is there a historical tradition going all the way back to the ratification of the Second Amendment that says we accept blanket bans on certain formats and types and platforms of firearms? Now, we know that clearly this is covered under the Second Amendment, and there is absolutely no historical tradition whatsoever for blanket platform bans in any way, shape, or form up until about the late 1980s. So again, the plaintiffs have made all the right arguments here. They also pointed out, quite obviously, that under the holdings of Heller, reaffirmed by Bruin, that these firearms are in common use. They are in common use for lawful purposes, and therefore we do not, as a society, ever accept the banning of firearms which are in common use for lawful purposes. Now, as it relates to the irreparable harm, what the state of California is essentially arguing is listen, if you allow Judge Benitez's ruling to go into effect, we're going to just be flooded with these weapons, and we're just going to have carnage on our street. As the plaintiffs put it in their reply brief, moreover, the state's irreparable injury burden must be higher than showing that there will be a, quote, a sudden surge of these firearms into California. The mere fact that more of these firearms will legally enter into this state does not in and of itself cause any harm, let alone irreparable harm. The state must show that this influx will actually lead to irreparable harm. And then they also pointed out that, well, you see, if you allow Judge Benitez's ruling to go into effect, and there is this sudden surge of these firearms, then when we, the state of California, prevail, well, it's going to be really, really hard. We're going to have a lot more difficult time going out and rounding them up. I'm serious. Plaintiffs pointed out, simply assuming that it will prevail, the state asserts that it would be impracticable, if not impossible, for the state to restore the status quo and remove all these weapons from the state. Okay, so the state of California is basically saying, hey, listen, if we allow people to start exercising their constitutional rights and legally obtaining these firearms, there is massive irreparable harm that we will never be able to recover from. How could we possibly go out and round up all those guns? The plaintiffs here, of course, pointed out, well, actually, the irreparable harm that we're suffering is a deprivation of one of our constitutional rights. And they wisely pointed out, on the other hand, irreparable injury to the plaintiffs and other similarly situated Californians is undeniable if this court should stay the district court's decision. It is well established that the deprivation of constitutional rights unquestionably constitutes irreparable injury to a party seeking to uphold an injunction. So as you can see, a really strong argument which is based in fact, common sense, reasonableness, sound case law, and sound constitutional principles, okay? And this was about 23 pages of hard, good briefing done by the plaintiffs here. How has the Ninth Circuit reacted? Well, they have ruled in favor, of course, of the state of California and have done so on a 1.5-page order. That's right. It is a 1.5-page order that the Ninth Circuit has offered. And let me read it to you because it states, in light of this court's published order granting a stay in Duncan v. Bonta, concluding that the Attorney General of California is likely to succeed on the merits and has shown that California will be irreparably harmed absent a stay, and the similarities between Duncan and this case, we grant appellant's motion and administratively stay the district court's October 19, 2023 permanent injunction and judgment. In granting an administrative stay, we do not intend to constrain the merits panel's consideration of the merits of this appeal in any way. The administrative stay shall remain in effect until the merits panel decides the appeal or issues an order lifting the stay. So there you have it. They have done exactly on this case what they did in Duncan v. Bonta, exactly as we predicted. Now, the only good news is that they have expedited oral arguments. The order of the court is, we sua sponte expedite this appeal. The opening brief is due November 9th, 2023. The answering brief is due November 22nd, 2023. The optional reply brief is due November 29th, 2023. No streamlined extensions of time will be approved. The clerk will place this appeal on the calendar for December 2023. And then Judge Callahan did author a very brief dissenting opinion, basically saying there's no way that the state is going to be prevailing on the merits. So you can see here, it should be pretty obvious at this point, the gamesmanship that is being played. So the good news is we will be able to expedite our trip to a full panel Ninth Circuit screwing a little bit sooner than we did. Ultimately, this case, as well as what's going on in Illinois. Let us not forget that Illinois has this registration requirement that is up at the end of the year. And they're talking out there like they're going to start rounding up some of these weapons. So things are going to get real interesting. These cases are obviously going to need to be expedited in a relatively quick fashion to the United States Supreme Court. The case, once again, is Miller v. Bonta. We'll link it all up down below so you guys can read the pleadings and read this incredibly brief order. It should take you about 15 seconds. In the meantime, if you've got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington Gun Law by now. If you don't, that's okay. That information is right down there in the description box. Now, in the meantime, let's remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.